Que no se te pasen los eventos conmemorativos por los 10 años de la Reforma Constitucional de Derechos Humanos y Amparo,
que podrás seguir en nuestras redes sociales. Conoce las sentencias paradigmáticas y de vanguardia de la Corte en temas como
derechos de las personas con discapacidad,
acceso a un medio ambiente sano,
libertad de expresión y acceso a la información,
igualdad y no discriminación,
libre desarrollo de la personalidad,
interés superior de la infancia,
derechos de los pueblos y comunidades indígenas, entre otros.
En la Corte se desarrollan y protegen los derechos humanos de todas las personas.
¿Ya formas parte de la comunidad SCJN Digital?
En las redes sociales de la Corte queremos escucharte.
Síguenos en Twitter,
Facebook,
Instagram
y YouTube.
Comenta y comparte nuestras publicaciones.
Entérate de las sentencias más importantes de la Corte que protegen ampliamente los derechos humanos de todas las personas.
Participa en nuestras transmisiones en vivo
Y conoce el patrimonio artístico del edificio sede de la Corte.
Suscríbete
Dale like.
y comparte.
Que no se te pasen los eventos conmemorativos por los 10 años de la Reforma Constitucional de Derechos Humanos y Amparo,
que podrás seguir en nuestras redes sociales. Conoce las sentencias paradigmáticas y de vanguardia de la Corte en temas como
derechos de las personas con discapacidad,
acceso a un medio ambiente sano,
libertad de expresión y acceso a la información,
igualdad y no discriminación,
libre desarrollo de la personalidad,
interés superior de la infancia,
derechos de los pueblos y comunidades indígenas, entre otros.
En la Corte se desarrollan y protegen los derechos humanos de todas las personas.
Conoce las sentencias de la Corte que protegen los derechos humanos de todas las personas.
Para ampliar tu conocimiento sobre el trabajo jurisdiccional, accede a los libros gratuitos,
Infografías,
videosentencias
comunicados oficiales.
y transmisiones en vivo.
Encuéntranos en Facebook como Suprema Corte de Justicia de la Nación.
Sigue nuestra página oficial
Y sé parte de la Corte Digital. No te pierdas todas las transmisiones en vivo de la Suprema Corte.
Suscríbete a nuestro canal y sigue de cerca las sesiones virtuales del Pleno y las salas de la Corte.
Los mejores contenidos de las áreas especializadas de la Corte los encuentras en la Corte Digital.
Suscríbete
Dale like.
y activa la campanita.
Sigue nuestra cuenta de Twitter @SCJN y entérate de la información oficial sobre la actividad jurisdiccional de la Suprema Corte de Justicia de la Nación, comunicados, convocatorias, cursos, conferencias y seminarios. Inscríbete a las actividades en línea y participa.
Que no se te pasen los eventos conmemorativos por los 10 años de la Reforma Constitucional de Derechos Humanos y Amparo,
que podrás seguir en nuestras redes sociales. Conoce las sentencias paradigmáticas y de vanguardia de la Corte en temas como
derechos de las personas con discapacidad,
acceso a un medio ambiente sano,
libertad de expresión y acceso a la información,
igualdad y no discriminación,
libre desarrollo de la personalidad,
interés superior de la infancia,
derechos de los pueblos y comunidades indígenas, entre otros.
En la Corte se desarrollan y protegen los derechos humanos de todas las personas.
¿Ya formas parte de la comunidad SCJN Digital?
En las redes sociales de la Corte queremos escucharte.
Síguenos en Twitter,
Facebook,
Instagram.
y YouTube.
Comenta y comparte nuestras publicaciones.
Entérate de las sentencias más importantes de la Corte que protegen ampliamente los derechos humanos de todas las personas.
Participa en nuestras transmisiones en vivo.
Y conoce el patrimonio artístico del edificio sede de la Corte.
Suscríbete
Dale like.
y comparte.
Que no se te pasen los eventos conmemorativos por los 10 años de la Reforma Constitucional de Derechos Humanos y Amparo,
que podrás seguir en nuestras redes sociales. Conoce las sentencias paradigmáticas y de vanguardia de la Corte en temas como
Derechos de las personas con discapacidad.
Acceso a un medio ambiente sano.
Libertad de expresión y acceso a la información.
Igualdad y no discriminación.
Libre desarrollo de la personalidad.
Interés superior de la infancia.
Derechos de los pueblos y comunidades indígenas, entre otros.
En la Corte se desarrollan y protegen los derechos humanos de todas las personas.
Conoce las sentencias de la Corte que protegen los derechos humanos de todas las personas.
Para ampliar tu conocimiento sobre el trabajo jurisdiccional, accede a los libros gratuitos,
Infografías,
videosentencias
comunicados oficiales.
y transmisiones en vivo.
Encuéntranos en Facebook como Suprema Corte de Justicia de la Nación.
Sigue nuestra página oficial
Y sé parte de la Corte Digital. No te pierdas todas las transmisiones en vivo de la Suprema Corte.
Suscríbete a nuestro canal y sigue de cerca las sesiones virtuales del Pleno y las salas de la Corte.
Los mejores contenidos de las áreas especializadas de la Corte los encuentras en la Corte Digital.
Suscríbete
Dale like.
y activa la campanita.
Sigue nuestra cuenta de Twitter, @SCJN, y entérate de la información oficial sobre la actividad jurisdiccional de la Suprema Corte de Justicia de la Nación, comunicados, convocatorias, cursos, conferencias y seminarios. Inscríbete a las actividades en línea y participa.
Que no se te pasen los eventos conmemorativos por los 10 años de la Reforma Constitucional de Derechos Humanos y Amparo,
Que podrás seguir en nuestras redes sociales. Conoce las sentencias paradigmáticas y de vanguardia de la Corte en temas como
Derechos de las personas con discapacidad.
acceso a un medio ambiente sano.
Libertad de expresión y acceso a la información.
Igualdad y no discriminación.
Libre desarrollo de la personalidad.
Interés superior de la infancia.
Derechos de los pueblos y comunidades indígenas, entre otros.
En la Corte se desarrollan y protegen los derechos humanos de todas las personas.
Hola, bienvenidas a esta última conferencia del ciclo de reformas de derechos humanos en la voz de Jueces y Juezas del mundo. El día de hoy vamos a tener la fortuna de escuchar a la jueza Andromache Karakatsanis de la Corte Suprema de Canadá, contándonos la experiencia sobre Canadá a la luz de su Carta de Derechos y Libertades de 1982. Les recuerdo que esta conferencia es parte del ciclo de conferencias que fue organizado por la Suprema Corte con el fin de reflexionar sobre la conmemoración de los 10 años de la Reforma de Derechos Humanos de 2011. De hecho, esta es la última conferencia. Ya hemos tenido la fortuna de escuchar la experiencia de 6 países distintos: Portugal, Alemania, Costa Rica, la India, Sudáfrica y finalmente Canadá. Eso representa países de 4 continentes distintos. El objetivo del ciclo fue como ustedes saben, conocer experiencias de distintos países, experiencias exitosas, de las cuales podemos aprender cuestiones que nos pueden ayudar a pensar nuestra propia realidad y a seguir trabajando en la implementación y consolidación de la reforma de derechos humanos de 2011. Agradezco al equipo de la Dirección General de Relaciones Institucionales por todo el trabajo que pusieron en la organización de este ciclo que hoy concluye. Antes de dar paso a la conferencia, pues me permito presentar a la jueza Andromache Karakatsanis, quien se graduó de la Universidad de Toronto y la Facultad de Derecho de Osgood Hall. En el sector privado fue litigante en las áreas de Derecho Penal, Civil y Familiar en Toronto por varios años. Posteriormente ocupó varios cargos de alto nivel en el Servicio Público de Ontario por 15 años. Durante su carrera en el sector público, se desempeñó como subprocuradora general adjunta y secretaria de Asuntos Indígenas, subprocuradora general y secretaria del Gabinete y del Consejo Ejecutivo de Ontario, entre otras posiciones. Durante su trayectoria en el servicio público, participó activamente en asuntos relacionados con la educación y la reforma de la justicia administrativa. En 1996 recibió la medalla de la Sociedad de Adjudicadores y Reguladores de Ontario por su aportación excepcional al sistema de justicia administrativa de dicha provincia. Antes de ser jueza de la Corte Suprema, fue jueza de la Corte Superior de Justicia de Ontario y de la Corte de Apelaciones de la misma ciudad. La jueza Karakatsanis fue nombrada jueza de la Corte Suprema de Canadá en octubre de 2011. Bienvenida, jueza, y damos paso a su conferencia. Muchas gracias.
Buenas tardes. My name is Andromache Karakatsanis, and I am a Justice of the Supreme Court of Canada. I am honored to contribute to your celebration of the 10-year anniversary of reforms to the Mexican Constitution. Today, I will be speaking to you about Canada's experience with human rights protections, especially under the Charter of Rights and Freedoms in our Constitution. But I start by noting that your court has a far longer experience with this topic than mine. The Mexican Constitution of 1917 provided robust constitutionalized protections of social rights and served as a model for many other constitutions around the world. Canada, by contrast, is a relative newcomer to having a constitutionalized Bill of Rights. Our charter will only turn 40 as of next year. However, the roots of our charter go much deeper than 40 years. The development of constitutionalized human rights protection in Canada is a long and at times troubling story. I will start by tracing some of that history and how we came to have a Charter of Rights and Freedoms in Canada. I then will go on to discuss in more depth how the Supreme Court has grappled with human rights in a few areas, particularly equality rights and limitations on state power. I hope to show that there is an arc that bends towards justice, even though there is still much more work to be done. Our parliamentarians gave the court a challenging task by entrusting it with as aspirational a document as the Charter. It results in the court playing a decisive role in deciding important and sometimes controversial social issues which touch the lives of all Canadians. This is a heavy responsibility, and we feel it keenly with each case. But the court does not do this task on its own. The protection of human rights is a shared project involving the other branches of government and the commitment of the people of Canada. It works only if the shared vocabulary of rights protection provided in our charter and the values resonate with everyday Canadians. I turn first to a brief history of human rights in Canada. In 1867, a confederation of British colonies in North America was created and named Canada, from the Iroquoian word kanata, meaning village or settlement. This new country had a legal system that drew heavily on British law, while also maintaining the French civil law tradition. The courts initially had a very limited role in protecting civil rights in this new country. Canada's first constitution, the British North America Act of 1867, was rooted in the British tradition of parliamentary supremacy. It included no Bill of Rights like the American Constitution. The view was that Parliament was the best protector of rights. But the first Canadian Constitution did differ from Britain's unwritten Constitution in important ways. For example, the Constitution created a federal structure. The federal structure was designed in part to balance and protect the culture, language, and religion of the French and English populations. The Constitution gave the provinces wide control over local matters, ensuring, for example, that Quebec would be able to enact policies beneficial to its predominantly French Catholic population. The Constitution also included some measures to protect minorities within the provinces. Section 93 protects Roman Catholic schools in Ontario and Protestant schools in Quebec. Section 133 protects the language rights of the two official languages, English and French. And in addition, Section 96 guarantees the tenure and inherent jurisdiction of the Superior Court judges. These specific protections and Canada's federal structure meant that judicial review was an important feature of Canadian constitutional law from the outset. In addition, Canadian law also inherited many of the civil rights protecting features of the English common law. However, the doctrine of parliamentary supremacy meant that those common law protections had no constitutional status and could be overridden by explicit legislation. As a result, a number of discriminatory laws were struck down as being outside the competence of the provinces to enact. But the limitations of the B&A Act as a rights-protecting instrument can be seen in a series of cases between 1899 and 1914 that mostly upheld blatantly discriminatory provincial legislation targeting Japanese and Chinese Canadians. This need for a more effective response to racial discrimination coincided with the development of an international trend towards the explicit elaboration of human rights. In many respects, the Age of Rights was a reaction to the horrors of the first half of the 20th century. And Canada passed its first Bill of Rights in 1960. The Canadian Bill of Rights recognized a broad range of human rights and fundamental freedoms, including many that were ultimately constitutionalized in the Charter. Every law had to be interpreted in accordance with those rights unless the law explicitly said otherwise. But the Bill of Rights was just a regular statute, meaning it could not apply to the provinces, and it could not restrict future parliaments. While its promise was never fully realized, the Bill of Rights nonetheless signaled an increasing openness to embrace the post-war model of explicit limitations on state action, and it set the stage for a constitutionalized Bill of Rights. A bigger project of constitutional reform would therefore be required to cement human rights protection into Canadian law. This project really began in 1967, 100 years after Confederation, when future Prime Minister Pierre Trudeau became Minister of Justice. Patriation, the process of bringing a new constitution home to Canada, required many years of negotiation. By 1980, 8 of the 10 provincial premiers remained opposed. A majority of the premiers were particularly opposed to the proposed Charter of Rights and Freedoms. So an intense period of compromise and negotiation ultimately resulted in 9 out of the 10 provinces agreeing to patriate the Constitution. Quebec did not sign on. The Constitution Act was passed in 1982 and established the Charter of Rights and Freedoms. The Charter is a product of those years of compromise, and this shaped its structure in a few very significant ways. I will highlight 2 features. First, the Charter includes a provision known as the Notwithstanding Clause that allows legislatures to override certain provisions in the Charter. This override must be explicit and must be renewed every 5 years. The hope was that political actors would pay a political price for overriding Charter-protected rights. Second, the Charter includes a general limitations clause contained in Section 1 that applies equally to all rights, so that the rights themselves are expressed without internal qualifications. The government that wishes to limit a right bears the burden of justifying the limit. The final language in Section 1 provides that the rights and freedoms it sets out are subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Thus, the Charter pairs a normative and rights-protecting general limitations clause with the Notwithstanding Clause, a very pragmatic Canadian compromise. Scholars have noted that this combination was essential to achieving the consensus necessary for patriation to succeed. So I'll turn now to the structure of the Charter of Rights and Freedoms. The Charter draws on many inspirations, including international human rights documents. The rights are set out in broad statements. You will immediately recognize the fundamental democratic and legal rights set out in Sections 2 through 14. Section 2 protects the fundamental freedoms, which include conscience and religion, thought, belief, opinion and expression, peaceful assembly, and association. Sections 3 to 5 protect democratic rights, including the right to vote and mobility rights. Sections 7 through 14 contain the legal rights. These include the right to life, liberty, and security of the person, the right against unreasonable search and seizure, the right to be free from arbitrary detention, and the right against cruel and unusual punishment. I will return to some of these legal rights later. Section 15 protects equality rights. I will also return later to this important provision. In addition, language and minority education rights are also specifically protected. As I just mentioned, these rights are affirmed in Section 1, subject to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. The Supreme Court provided the framework for this limitations provision 4 years after the Charter came into force, in a 1986 case called the Queen and Oakes. It adopted a proportionality approach, now a common feature of constitutional law in many countries. If the government limits a right, it must first demonstrate a pressing and substantial objective. If it does, the limit on the right must be proportionate. This means that there must be a rational connection between the government objective and the means chosen. The means chosen must minimally impair the right, and the harm must not outweigh the benefit. And finally, Section 24 provides just and appropriate remedies for breaches of the Charter, and our court has held that this section should be given a generous and expansive interpretation. There are some important differences between the Charter and other bills of rights. For example, the Charter does not include economic and social rights, like your Constitution, as well as the constitutions of South Africa, India, and other countries. Another feature not shared with all constitutions is that the parties need standing to initiate a challenge. There is no direct access to the Supreme Court. A challenge will usually start at a court of first instance, work its way up through the provincial or federal court of appeal, and then the Supreme Court decides whether to grant leave to an appeal. This usually ensures we have the adjudicative facts on which to ground the analysis of whether there is a charter breach. And in cases dealing with a public interest challenge to the constitutionality of a law, that we will have the benefit of prior reasons. The federal government, however, is allowed to pose a reference question directly to the Supreme Court of Canada. One final observation is that the provisions of the Charter are drafted broadly, and the courts are expected to fill in the details over time through the common law method. It is also very hard to amend the Charter. The amending formula sets a very high bar. Outside of the Charter, the 1982 Constitution also included new protections for Indigenous peoples. Section 35 of the Constitution Act 1982 provides, "The existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed." Indigenous rights are undoubtedly fundamental rights, but they are sui generis, unique, and this separation from the Charter recognizes their distinct origins. In fact, Section 25 of the Charter provides that the individual rights guaranteed in the Charter cannot be used to abrogate or derogate from Aboriginal or treaty rights enshrined in Section 35. This is slightly different from the approach taken in your Constitution, I believe, which protects Indigenous rights while affirming that they are subjected to other fundamental rights in the Mexican Constitution. Our court has determined that these Aboriginal rights must be interpreted in light of what we call the honor of the Crown, an obligation that arose when the Crown asserted sovereignty over territories already occupied by Indigenous peoples. The honor of the Crown grounds the fundamental purpose of Section 35, reconciliation. This includes the reconciliation of the assertion of sovereignty with the pre-existence of Indigenous peoples and the project of reconciling Indigenous and non-Indigenous peoples and their respective claims, interests, and ambitions. Section 35, and the honor of the Crown more broadly, gives rise to a number of obligations on the state, including a fiduciary duty, the duty to consult when government action could impact an Indigenous right, even if the right has not been fully established yet, and a clear requirement that the government justify any infringements of protected interests. This area of law remains very much a work in progress, but Canadian courts have provided a framework to address the complex reality of Canada's history and the challenges and opportunities ahead. The Charter came into effect in 1982, the year I became a lawyer. As you can imagine, the 1980s were a very productive and creative period in the evolution of the Supreme Court of Canada. Originally, the Supreme Court was primarily a court of error correction, with little control over its docket. That changed in 1975, when the automatic right of appeal to the Supreme Court was eliminated in most cases and replaced by a requirement for the court to agree to hear an appeal. This changed the court's focus from one of error correction to supervising the development of Canadian jurisprudence. The Charter changed the role of the court and the nature of our cases yet again. Now, legislation had to comply with the Charter, and the court's authority and obligation to determine whether a law is inconsistent with the Constitution, and if so, to declare it to be of no force and effect, is constitutionally entrenched in Section 52.1 of the Constitution Act. As noted in an early charter case, the court did not seek out this role for itself. Parliament and the provincial legislatures gave this role to the court, and they gave the court a broad rights protecting document that needed to be interpreted. Therefore, the early charter decisions were partially concerned with how to go about interpreting the charter. The interpretation would need to be different from the constrained approach taken to the Bill of Rights, because the charter was not an ordinary statute. The first interpretive principle, drawn from the court's experience with the 1867 Constitution, was that the Charter was, quote, a living tree capable of growth and expansion within its natural limits, end quote. This is a metaphor that has been widely used in our jurisprudence. This quote comes from an important 1929 decision called the Persons case. The Supreme Court applies this approach to the Charter, and the Charter must be given an interpretation that recognizes that it is capable of growth and development. The second feature of Charter interpretation is that rights are to be interpreted in a broad and generous fashion. This was contrasted with a legalistic approach. The final feature is that rights are to be interpreted purposively. Generous interpretation and purposive interpretation are obviously linked concepts, because the aim of the generous approach is to fulfill the purpose of the right, as the court recognized in a 1985 case called Big M Drug Mart. Once a court determines the purpose of the right, this purpose frames the generous interpretation that the right can bear. In Big M, for example, the court interpreted the purpose of freedom of religion broadly, that every individual be free to hold and to manifest whatever beliefs and opinions his or her conscience dictates, provided that they don't injure others. I have sketched out a quick story of Canada's transition to a constitutionalized Charter of Rights and Freedoms with robust judicial review. The path has not been straightforward, but there is a clear arc towards more and more robust rights protections within Canada. For the remainder of this lecture, I want to delve into a few distinct areas where the courts have advanced the cause of human rights in the post-charter era, specifically equality rights and limitations on state powers. I will start with equality. Section 15 is one of the most consequential provisions in the Canadian Charter. It provides that every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Courts did not initially have a clear sense of how to interpret this broad formulation of the idea of equality. The Supreme Court of Canada's first attempt to bring structure to the analysis was in a decision in 1989 called Andrews, which dealt with a British citizen who met all the requirements to become a lawyer in British Columbia, but was denied because he was not a Canadian citizen. The most difficult question in Andrews was what type of distinction would count as discriminatory. The court's answer was to focus on distinctions that imposed a burden or withheld a benefit from the claimant. Over the next 3 decades, the court wrestled with the governing framework for equality rights. But recently, the court has largely relied on the original framework from Andrews, but with an emphasis on substantive equality. The issue is not whether everyone is being treated the same, but how even seemingly neutral laws actually impact people in their unique context. The most important question is whether the challenged law imposes a burden or denies a benefit in a manner that has the effect of reinforcing, perpetuating, or exacerbating disadvantage, including historical disadvantage. Despite the sometimes rocky path of its development, Section 15 has pushed substantive equality forward in a number of significant areas. One such area is the evolution of the LGBTQ 2S+ equality rights in Canada. While sexual orientation is not an enumerated ground in Section 15, the court had decided in a 1995 decision that it was an analogous ground, equally protected under Section 15. There's that living tree analogy again. Canada has a long history of discrimination based on sexual orientation. Until 1969, homosexual acts were criminalized under the Criminal Code. And it was only in 1997 that the federal parliament added sexual orientation as prohibited grounds for discrimination under the Canadian Human Rights Act. In the 1990s, various legislative schemes that restricted rights and benefits to opposite-sex spouses were challenged under the equality guarantee in the Charter. In 1999, the Supreme Court evaluated the definition of spouse against the equality provision. In M versus H, one of the parties sought spousal support upon breakdown of a long-term same-sex relationship. She challenged the definition of common law spouse in the Ontario Family Law Act, which was restricted to a union between a man and a woman. The court held that the exclusion of same-sex couples from the spousal support scheme was discriminatory and violated the Charter. At the time, I was Deputy Attorney General in Ontario, the senior public servant in the Ministry of Justice. Even though the case focused on a single definition in a single piece of legislation, it had ramifications for many laws that excluded same-sex couples, including pension benefits, tax credits, and adoption eligibility. We led Ontario's response to the M versus H decision. Instead of waiting for other legislation to be challenged and declared invalid, we reasoned it best to be proactive. The government introduced a bill that amended 67 laws to give same-sex partners the same rights and benefits as unmarried opposite-sex partners. The legislation was called Amendments because of the Supreme Court of Canada decision in M versus H Act. The next hurdle was the definition of marriage. In the years following M versus H, several couples challenged the definition of marriage in federal legislation. A number of provincial courts of appeal found that these definitions, which excluded same-sex couples, infringed the equality guarantee. It was now the federal government's turn. It responded in 2003 by drafting a bill that would give same-sex couples equal rights to marry. It sent the proposed legislation to the Supreme Court for what is known as a reference, essentially seeking the court's views on the constitutionality of the proposed legislation. The court confirmed that Parliament held the constitutional authority to make these amendments. Parliament passed the legislation, and same-sex marriage was recognized across the country. Resolving these important issues in Canada is not solely up to the courts, nor should it be. Rather, the courtroom is where the three independent branches of government, the legislature, the executive, and the judiciary, come together. The federal and provincial governments in this case took steps to ensure that their laws were compatible with the development of jurisprudence concerning sexual orientation equality. This is an example of what has sometimes been called the dialogue between government and the courts. In my view, one important contribution that courts made to this area was a language for discussing equality. The shared vocabulary and context in our jurisprudence helps raise the issues from the emotional level to one of principle. It creates a legal framework that is intelligible and capable of consistent application. This, in turn, helps ensure that the decisions on difficult social matters are seen to be legitimate by Canadians. Next, I want to discuss the effects that the Charter has had on the limits of state power in the field of criminal law. The intersection between the Charter and the criminal law represents one of the busiest aspects of the Supreme Court's docket. Most Charter protections can be engaged in criminal settings, including freedom of speech and equality. However, the real core of the Charter's effect on the criminal law comes from the legal rights provisions, sections 7 through 14 of the Charter. I want to focus on two of these protections, Section 8, which protects everyone's right to be secure against unreasonable search and seizure, and Section 7, which protects the right to life, liberty, and security of the person. These two rights protect the ability of Canadians to go about their daily lives without the fear of undue state intrusion, and have developed in ways that protect the marginalized in society and ensure that they receive the benefits of the law. The right to be secure against unreasonable search and seizure is inextricably linked with privacy. State action will only be a search or seizure where it engages a reasonable expectation of privacy. For example, the police looking at you will not be a search. If you're on a public street corner, because there is no reasonable expectation of privacy in that setting, it won't be a search. However, if police enter your home or use a camera to look at you inside your home, then there is an obvious expectation of privacy and the Charter will be engaged. Our court has held, whenever a privacy interest is engaged, the search is presumptively unreasonable unless the police first obtain a judicial warrant, except in exigent circumstances. Historically, there has been a strong link between privacy and property, what we call territorial privacy. From the English common law, we inherited the famous dictum that the house of every one is to him his castle and fortress. More recently, our jurisprudence has recognized a normative approach, which focuses on the long-term consequences of government action for the protection of privacy. Thus, the Supreme Court of Canada has recognized broader personal and informational privacy interests. As examples, the court has recognized privacy interests in hotel rooms, rented bus lockers, internet subscriber data, and sent text messages stored on another person's phone. Our court has repeatedly been called on to strike the balance inherent in Section 8 jurisprudence to permit effective law enforcement while protecting the privacy interests of all members of society. This is especially challenging in the context of personal digital devices. In the 2014 case of Fearon, police arrested a man suspected of armed robbery of jewelry. They seized and searched his cell phone and discovered incriminating evidence. The court was unanimous that cell phones must be treated in the same way as a personal computer. However, the majority of the court ruled that a search and seizure of a personal digital device upon arrest was legal, but with various safeguards. As is sometimes the case at the Supreme Court, this decision was not unanimous. In fact, it was quite close, a 4-3 split. I wrote the dissenting judgment in Fearon. I would have gone further. My reasons emphasize the unique and pervasive privacy interest in personal computers as portals to our digital life, holding vast stores of information. I thought it deserved the same protection we provide to our homes and required police to obtain a judicial search warrant to search the contents of the phone. In 2018, we once again grappled with privacy and personal digital devices in a case called Reeves. The accused shared a computer with his common-law spouse, who had authorized police officers to seize the computer. The court emphasized the extensive privacy interests in personal computers. A person does not lose their expectation of privacy in a computer by sharing it with others, and that one shared user cannot waive the charter rights of the other. This time, however, I wrote on this issue for an 8-1 majority. Clearly, one of the outcomes of having 9 judges on the court is that we will not always agree on what is the constitutional balance to strike in any particular situation. But disagreement among judges is healthy, can generate public and scholarly debate, and as we will see with the example that I will speak about next, that minority decisions of today can become majority views in the future. Section 7 protects the right to life, liberty, and security of the person, and not to be deprived thereof except in accordance with the principles of fundamental justice. In the early days of the Charter, there was a debate over whether the principles of fundamental justice were purely procedural, protecting only procedural fairness, or whether they provided substantive protections. In 1985, our court rejected the narrow procedural view and held that Section 7 was a substantive right. Our court has called the principles of fundamental justice the basic tenets of our legal system. They are legal principles for which there is a significant societal consensus, that they are fundamental to the fair operation of the legal system, and they can be precisely identified to provide a manageable standard by which to measure deprivations of life, liberty, or security of the person. Perhaps the most consequential principles of fundamental justice are the principles that laws should not be arbitrary, overbroad, or disproportionate. These principles have been applied by our court to find criminal offenses to be unconstitutional. In a 2015 decision called Carta, our court was tasked with deciding whether the criminal code offense of assisting suicide infringed the Section 7 right because it prohibited physician-assisted dying. Just over 2 decades before, in a case called Rodriguez, this court had ruled, in a narrow 5-4 split, that the prohibitions were constitutional. At the time, though, the principle of fundamental justice, that laws must not be overbroad, had not yet been recognized. As the social context evolved and as physician-assisted dying continued to be debated both in Canada and around the world, the issue returned to the Supreme Court. This time, the court was unanimous. The prohibitions were unconstitutional. While they were intended to protect vulnerable persons from being induced to commit suicide in a moment of weakness, the law went beyond this and prevented persons with disabilities from acting on considered, rational, and persistent wishes to end their life. The criminal prohibitions were declared by our court to be of no force or effect insofar as they prevented adults who consented to dying and who had grievous and irremediable medical conditions that caused intolerable suffering from accessing physician-assisted dying. Section 52 of our Constitution empowers the court, as I've said, to declare legislation to be of no force or effect to the extent that it is inconsistent with the Constitution. Unlike Article 105 of the Mexican Constitution, any constitutional challenge to a law that is heard by the Supreme Court may result in a declaration of invalidity of general effect, whether the decision is decided 9-0 or 5-4. Carta was certainly not the first time our court found that criminal legislation was unconstitutional on the basis of Section 7 of the Charter. In the 1988 Morgentaler decision, the court struck down abortion restrictions. In the 2013 Bedford decision, our court found that criminal laws regulating sex work also infringed Section 7. As these landmark decisions show, cases where the court was tasked with examining abortion legislation, physician-assisted suicide, equality for same-sex couples, they provide a clear illustrations of the manner in which the Charter has shaped the court's role, and the court has shaped the role of the Charter. I have focused on the Charter, which guides the relationship between individuals and the state. The Charter does not, however, address relations between private actors, like employees and employers. That is where the federal and provincial human rights codes come in. These codes protect Canadians from discrimination in the workplace or discrimination in the provision of services. We have said these human rights codes are quasi-constitutional in nature. They serve a vital role protecting human rights in Canada. They are accessible to everyday Canadians and are supported by human rights commissions and tribunals. The commissions do not only investigate individual claims, they also provide essential research and advocacy. In conclusion, the courts are a venue for resolving the disputes that arise as a result of our complicated and at times unjust history. But the court does not do this alone. The concepts that the court relies on, such as substantive equality and principles of fundamental justice, are important values that need to be lived out in Canadian society. The court plays a limited role, although an important one, in advancing these values. The court's role is to interpret the law and the Constitution, and it does so in a socially responsive way. The experience of judging at a high court is defined by unique challenges, the need to balance the finality and the flexibility of the law, to maintain collegiality, and to participate in shared decision-making processes, and to ensure public confidence in the court. In contending with these challenges, High Court judges contribute to the evolution of the law in ways that profoundly shape society. As I've said, the Supreme Court of Canada was given this important task by the people of Canada. Canadians value their charter, with one poll showing that the charter is the number one thing Canadians view as uniting the country. The 9 judges of our court, who represent different regions, backgrounds, and even legal systems, do not always agree with what the path forward on a given case should be. However, this is part of how Canadian law grows and develops, and that development has been one of continued and increased equality and justice, an arc that bends towards justice. Thank you for your attention. Merci. Gracias.
Esta excelente conferencia, muy rica en contenido. Les agradecemos a quienes nos acompañaron. Infortunadamente, el día de hoy, por razones de agenda de la jueza, no vamos a poder tener un apartado de preguntas y respuestas, pero les invitamos a seguir participando en el resto de las actividades organizadas para la conmemoración de los 10 años de la Reforma de Derechos Humanos de 2011. Hasta la próxima.